Yes, what do you want?
Adjournment for the day, Your Lordship.
You are for the appellant.
Yes, Your Lordship.
What is your name?
R.A. Majumdar on behalf of D. Hussain.
On the prayer of Mr. R.A. Majumdar, learned counsel, appearing on behalf of the applicant stroke appellant. This matter stands adjourned for the day.
Oblige, Your Lordship.
For admission, item 1.
What happened? No PP today?
Fair losses. My lord, we are against the impugned order of the learned session judge. Your lordship, so many drawbacks are there in the case. In IL lordship may kindly see page 7 is the order. Here, a large number of drawbacks are there, my lord. The victim girl once said that she had sustained injuries by falling from guava tree. And later on, she was. May I continue, my lord? Later on, it was said by her that this accused person has asked her to bring some BD, etc., and thereafter committed that bad work. Now, thing is this: she is changing her version every now and then. That is first one. Second thing is that our clear case is that they are in our land and our custodial house, they were given free to live for some time. But when we asked them vacate the land and our house, thereafter this case was filed.
Where is the medical report?
Yes, my lord. Medical report that may be seen, my lord. Medical report that is. That is, my lord, page 20. My lord, page 20. Page 20. Your lordship would see bodily injuries. Page 20, almost bottom. No body injury detected. Then lordship would see page 21.
All right, we'll admit this appeal. Mr. Das, you are appearing. You take the heard Mr. M.U. Mahmood, learned counsel appearing for the appellant. We have also heard full stop reply. Mr. D. Das, learned additional public prosecutor, Assam, appearing for the state. Full stop. This appeal against conviction is directed against the judgment dated 14/11/2022, passed by the learned additional sessions judge, come special judge, bracket POCSO, POCSO, bracket close, Barpeta, in connection with special POCSO case number 25 of 2018, convicting the sole appellant under section 6, read with section 5 bracket small I bracket close and bracket small m bracket close of the POCSO Act, and sentencing him to undergo rigorous imprisonment for 12 years and also to pay a fine of rupees 20,000 with default stipulation. Full stop. We have gone through the impugned judgment and have also considered the submission made by the appellant's counsel. Full stop. Admit the appeal, call for the LCR, stop. Issue notice returnable in 6 weeks. Stop. Since Mr. Das, learned FEP Assam, has accepted notice for the respondent number 1 public state. No formal notice is required to be sent to the respondent number 1. The appellant to, however, take steps by registered post with AD for service of notice upon the respondent number 2. List the matter accordingly.
But may I also pray for dusty service is possible, my lord.
Dusty service in criminal matters, you take steps, we'll see what happens.
Item 2.
What is this matter?
My lord, this matter has been filed by the father of the victim, my lord, for CBI inquiry. As per the allegation, my lord, his son has died in police custody due to police torture, my lord.
Hmm.
I am appearing for the officer in charge, my lord, investigating officer, my lord. I have been made by name party, my lord, in this case, my lord. So I have appeared. I have filed my affidavit, my lord. Respondent number 8, my lord.
Who is appearing for the petitioner?
Mr. Senior Advocate, Mr. A.M. Bora's name has been shown, my lord.
You are for whom? Respondent number 8.
8, my lord.
And for the other respondents,
My lord, GA Assam, my lord. State, my lord.
not available. All right, then we'll adjourn it. Hmm. Take down, none appears for the writ petitioner when the matter was called up before this court today. Stop. Mr. M.K. Sharma, learned counsel for the respondent number 8, submits that an affidavit on behalf of his client has already been filed, which is on record. We find that this matter was adjourned by order dated 27/7/2022 on the request of the petitioner's counsel seeking 2 weeks' time to file a rejoinder responding to the affidavit in opposition filed by the respondent number 8. First of all. However, office note indicates that no such rejoinder affidavit has yet been filed. First of all. Under the circumstances, we are left with no option but to adjourn this matter for 3 weeks so as to enable the petitioner's counsel to file rejoinder affidavit. Stop. The respondent numbers 1 to 7 may also bring their stand on record by filing affidavit in the meantime. The respondent 1 to 7 may also in the meantime bring their stand by filing affidavit.
Orders item 3.
But in this matter, the appellant has taken the brief, Lord. And now we are not there in this council,
Appellant has taken away the brief.
Lord.
Why? Why didn't you stop him?
Lord.
Oh. All right, then we adjourn it.
Lots,
Uh,
that's on for 2 weeks, lots.
2 weeks now before vacation
Lots.
is not working. You take down, heard Mr. D. Das, learned counsel. Earlier appearing for the appellant in this case, who submits that his client has taken away the brief and therefore he is no longer, along with his associate, along with his other colleagues, are no longer authorized to represent the appellant in this case. In view of the above submission made by Mr. Das, registry to verify as to whether any fresh set of counsel have entered appearance on behalf of the appellant, and if no, we'll see whether a legal aid counsel have appeared and have entered appearance on behalf of the appellant, and list the matter again after 4 weeks with appropriate office note. Full stop. The appellants, the earlier engaged counsels of the appellant would be at liberty to approach the registry by making proper application for deleting their names from the record of this case, if so advised.
Completely okay.
Item 4.
Please, Your Lordship. Service in respect of the private respondent number 2 is awaited, Lordship.
Private respondent, who is the private informant?
Yes, Your Lordship.
Why is it necessary to serve the informant here? Who is the informant?
Informant is the father, Lordship.
Father of the victim.
Yes, Your Lordship.
Then we have to await service report. Is it not? All right, you are Mr.
My name is B.B. Kakoti.
Heard Mr. B.B. Kakoti, learned counsel appearing for the appellant. Full stop. Mr. D. Das, learned APP Assam is present on behalf of the state public respondent number 1. Full stop. Office note dated 14/11/2022 goes to show that service report on the informant stroke respondent number 2 is still awaited. Full stop. Since the informant in this case is the father of the victim, service of notice upon him cannot be readily dispensed with. Stop. As such, registry to await service report on the respondent number 2. Let the matter be listed again after 4 weeks with appropriate office note.
Obliged, Your Lordship.
Item 5.
Late please, Your Lordship. Lordship, on some personal ground, my senior is out of station. Can the matter be adjourned for the day? And any date may be fixed after vacation, Lordship.
What is this IA for?
And the I is for bail, Lordship.
IA is for
Bail,
bail.
Lordship.
You argue, we'll take it up today itself.
Lordship, I am very new to the chamber exchange, Lordship.
Very new. How new?
Just 4 or 5 months, Lordship.
Oh, that's a long time.
Lordship, any date.
State has filed objection. Mr. Das,
Perhaps not in my view, that is not there.
your brief, it is not there.
No, in my brief, that objection is not there. But, because Bernale Bhuya and Julie is appearing in this court. They are acquainted with these things.
Where is she? She has not come.
She has some personal things. She will be coming after a while. Actually, my presence before lordship is stopgap arrangement. I'm sorry, my lord.
Objection filed. Objection is there.
It is not there with my file.
So same prayer was made on the last date also. Personal difficulty, personal difficulty.
Lordship, actually, my senior is out of station on some personal grounds.
Once again, expressing personal difficulty on the part of the arguing counsel, Mr. T.H. Hazarika, the applicant has sought adjournment when the matter was called up before this court. Full stop. The IA has been filed with a prayer for suspension of jail sentence and also for releasing the applicant on bail. Full stop. Ordinarily, these matters ought to be taken up for expeditious disposal. Full stop. However, since the applicant's counsel is not ready to argue the matter before us, we are left with no option but to adjourn the matter as prayed for. Full stop. Let this IA be listed again after 2 weeks. Stop. Mr. D. Das, let this, as prayed for, let this IA be listed again after 2 weeks. Mr. D. Das, learned APP Assam, is present as a stopgap arrangement, is it? That should not be written. Achha. No stopgap, don't write that. Mr. D. Das, learned APP Assam is present.
Obliged.
That is of the record arrangement. That is of the record arrangement.
Item 6 to 8.
Here in this case, I am appearing for item number 6 and 7, Lordship. May I appear Lordship, this matter will be adjourned for the day, Lordship. I have prepared one compiled number, I could not verify it, Lordship. So on next day, Lordship, I will submit.
What is this? All cases are listed, then adjourn.
I'm sorry, Lordship, this I could not verify this compiled.
This adjournment culture, should it not stop now? Cases are listed, only 15-20 cases are listed. There are also 80% cases. Only prayer is adjournment. Very sad, and people are languishing in the jail. You could have verified it last night.
Okay, Lordship, otherwise I'm ready with next item, item number 12, Lordship.
Next item we'll talk about when it is called up. What about this item? You are appearing in which case?
6 and 7, Lordship.
And what about 8? Who is appearing?
Item number 8. I'm ready.
All right, if you are not ready, you take down. Mr. A. Ahmed, learned counsel for the applicants appearing item numbers 6 and 7. You give the case numbers, huh? One number 6 and 7 question. You write the case number. 6, adjournment. So as to, on the ground that some more preparation is required to argue these matters before this court. Mr. Full stop. Mr. L.R. Majumdar, learned counsel for the applicant, appearing in item 8, also makes a similar prayer. Full stop. All these 3 interlocutory applications have been filed with a prayer for suspension of sentence and also for releasing the applicants on bail. Full stop. However, now bail. Stop. Ordinarily, these matters are required to be taken up by the court for expeditious disposal. Full stop. However, if the petitioner's counsel, if the applicant's counsel are not ready to argue the matter, the court is left with no option but to adjourn, but to grant adjournment as prayed for. Full stop. How much adjournment?
Only for the day, Lordship.
On the request of learned counsel for the applicants, these matters stand passed over for the day. Stop. Mr. D. Das, learned APP Assam, is present on behalf of the state in all the matters.
Obliged.
Item 10.
May have little lordship. My lord, here
What is this?
I have made some important points and also some citations. My
Oh,
lord.
Mr. Mahmood, you keep it, don't give this kind of papers to the court. These are your personal notes. Don't give it. If you want to
Yes.
give something to the court, give it in a proper manner.
Uh,
Type it out and give it. Nobody does it, except you, nobody does it. You can't scribble something and give it to the court.
No, my points are.
No, whatever your point is. There are some court decorum.
No, that's true.
But because the judges are accommodating, that doesn't mean people should take undue advantage
Yes.
of that.
No, my lord, I am not on that. First, my lord, my submission is this is a clear case of acquittal, my lord. Because lordship may kindly see page 54.
What is this IA for?
My lord,
What is the, you are appearing?
My lord, I am appearing for the victim and I am legal aid counsel, my lord.
Okay, and Mr. Das, you are for the state.
My
Ready with the matter?
But I will file objection, my lord,
You will file objection.
my lord, because.
the objection is already filed by PP, my lord. I think that will do that. They have filed.
They filed already. Why?
Otherwise,
should
but
it-
I have objection, my lord, otherwise.
No, that you can,
My
you
lord,
can
my-
take your stand orally.
my- my-
Have you seen the objection filed by the state?
Oh, my lord.
Yes, this is the objection of state.
I mean, I promoted the other perspective. I have just received yesterday, I have just received the copy, my lord.
We'll take it up on Monday then. You come up with a type copy of what you want to give.
Yeah,
Later
that-
also go through. Monday, you are there?
I am here, but that's actually well, another incident has happened.
Hmm.
My wife has been admitted today in hospital for delivery for the first time. She weepingly told me yesterday, this is my condition, and otherwise, lordship, I will satisfy. Kindly bear with me. My learned friend may object on the basis of record. I also basis. Actually, there is no case. She stated before the doctor that I have love affairs with this person since last 6-8 months. And I have been compelled to file the present case because my husband threatened me that unless you file the case, you will be divorced. And it is said that there is a village bichar in connection with this case. There is 2 days delay, whereas the police station is nearly 10 minutes away from the place of offense. Now, Iowa asks whether you have examined any person of bichar party. Iowa said no. Now, Iowa has not sent anything for forensic examination, and her clear case is I love her. And our case is that I am a owner of a chart house, and they used to take so many items from my shop, and huge amount became to be given by them. And when I demanded that, then they filed this case. But the wife says that I was compelled to file the case, and I have love affairs with him. Since I am on record, my lord. I invite lordship kindly have a look at page 54. My wife is extremely critical condition. She is in hospital. My submission may be recorded. If your lordship kindly grants bail, that may be also recorded. He was weeping the other day that, sir, unless it is, I will die. Because
All right, let us see.
Yes.
What is the material?
page 54, kindly see. Page 54, she narrated before the doctor.
1 minute, 1 minute. Then you have to stop the.
Service to complete one another.
Well, in this case, the accuser preferred appeal for the, and M. Custodial was also appointed, but subsequently I am engaged, my lord. I have filed a vocal number and the memorandum of appeal in the name, and filed a petition, I have for the releasing the accusation bail, my lord. The notice was issued to the complainant. I don't know whether it was issued or not. It
I
is in
think
the
AD
petition
card has
file.
not been returned back.
This is what POXO matter.
No pokso, my lord. It is actually, case was registered on 325. And after 2 days, the accused died. And thereafter it was converted in 302. But the totality of the evidence on record, the whole case is doubtful, my lord. The involvement of
That is
the-
every case.
My lord,
Every case is doubtful.
yes.
Every case where conviction happens, doubtful, lot of problems.
No, conviction, my lord, there is no question why he was convicted on a 302, I fail to understand, because according to section 300 IBC, there must be intention on the part of the accused to kill the deceased. And secondly, he must have knowledge that the injury that he has caused is sufficient to cause death, cause instant death, my lord. Number 3 is sufficient for injury. Here the evidence of record state that the accused was going or deceased was going to collect the cows from the field on the date of his offense, only at 4:30 PM. At that time, most interesting, two boys were there who were chasing the cows. And in the meantime, the accused also appeared here, he had to collect his dog. According to FIR, that he has assaulted the deceased in the backside with a split bamboo, my lord. So what the most interesting is two boys who were chasing the cows.
Just 1 minute, just 1 minute.
Deceased were not.
Ago, 1 minute, I go order to Lisidio. The learned trial court would be at liberty to impose any other condition for releasing the applicant on bail for the period of 3 weeks, if so desired.
The two boys who were chasing the cow prior to the in presence of the deceased were there, and the two boys were chasing the cows and the deceased, and thereafter accused appeared here. So whether the assault has been caused by that two boys or by the accused, that is not as happened. Most interestingly, that two boys were not examined, my lord. Why they are even the most material witnesses were there, they were there, but they were not examined, my lord. So ruling of the most material witness has cast a serious doubt as to fairness of the prosecution case, my lord. And thereafter, what if the police registered a case under section 325 without medical examination, my lord? So he should have been medically examined first. What is the injury he has sustained as a result of the so-called assault made by the accused, my lord? So all the postmortem report was there. According to witness, only one assault was made in the backside area, but the doctor has found many injuries, my lord. The evidence of the
So,
doctor.
all right, but
Lordship, we have not filed an objection. Let this matter may come up after 10 days.
she wants to file
Objection
objection.
has filed much earlier days.
Who is an agent?
Yes, objection has filed, my lord. I have received the copy. You can think of-
Yes, yes,
Jahan.
objection is
Jahan.
filed.
Jahan has
Yes,
filed the copy.
I don't have anything with
received-
me today. Lordship, on coming week then, Monday or Wednesday.
Coming week, next week.
Jahan Nayaziga.
That's up to your lordship, if you're here.
Yes, yes, heard Mr. K. Sharma, learned counsel for the applicant, also heard Ms. B. Bhuya, learned AP Assam, who has made a request to post this matter again in the next week, as her colleague, Ms. S. Jahan, learned APP, who is handling this case, is not available today. Prayer allowed, let the matter be listed accordingly. Yes.
Okay.
Next week, next week.
Next week.
Item 12.
Let your lordship. This is POXO matter.
Lordship,
Uh,
live streaming.
POXO matter, close the lights. Victim and informant are the same. Is it?
Same man, because his father was a victim man.
He expired.
Yes. He is crime now. Now his mother is also a victim, my lord. Because mother of the deceased, my lord. Now he wants to continue with the proceeding, my lord.
Your Lordship on earlier occasions allowed similar kind of
And
petition.
there is a division bench of this court also, my lord, at this point, my lord. That under by exercising inherent power, they court the justice. And Ali, my lord. How fast is that?
Episode court, upon court is-
Some other judgment came after
Yes,
this.
ma'am.
Yes, ma'am.
Order, your Lordship passed order in D Talukdar's matter, if I am not wrong.
All right.
Yes, sir.
Yes, what do you want to say?
I have objected that till that CRPC has no provision for substitution, like a CPC.
Hmm.
Okay. Except this, I have no any problem.
So there is a judgment which says it will not abate.
If
Yes, heard Mr. P. Kotapi, learned counsel for the applicant, also heard Ms. B. Bhuya, learned APP Assam, learned senior counsel in APP Assam, assisted by Mr. J. P. Das, appearing for the state. Mr.
And so here appearing for 2 to 17.
Mr. N. Sekia, learned counsel, has appeared on behalf of the respondent numbers 2 to 17. Full stop. The deceased husband of the applicant had preferred an appeal against the judgment and order of acquittal passed by the learned trial court, acquitting the respondent numbers 2 to 7 in connection with sessions case number. What was the sessions case number?
Yes, I mean. One second, please. The sub case number, my lord, 30 of 2013, my lord, Morigaon, my lord.
In connection with Morigao sessions case number 30 of 2013. Full stop. Aggrieved by the judgment of acquittal, the husband of the applicant, who is the informant in this case, had preferred criminal appeal number 103 of 2020, which has been admitted to formal hearing by this court. Full stop. During the pendency of the appeal, the husband of the applicant has expired. Full stop. Hence, this IA for seeking leave of this court to allow her to pursue the appeal. Full stop. By placing reliance on a decision of this court in the case of legal heirs Srimati Malaya Das versus State of Assam and others, reported in 2019 bracket 3 bracket close GLT 364. Mr. Kotaki submits that on the death of the appellant, the appeal against acquittal would not abate and the legal heirs would have the right to be substituted. Full stop. Responding to the above, Mr. Saike submits that there is no substitution of there is no provision for substitution of legal heirs in the CRPC. Full stop. Ms. Bhuya, learned APP Assam, submits that she would have no objection to the application filed by the applicant. Full stop. It appears that the appeal has been preferred under section 372 of the CRPC. The appeal against acquittal has been preferred under section 372 of the CRPC. Full stop. Whether or not there is any provision for substitution of legal heirs, it cannot be denied that the on the death of the informant, the legal heirs of the informant would be entitled to pursue the appeal, more so since the appeal has already been admitted. Full stop. In view of the above and considering the decision of this court rendered in the case of legal heirs Srimati Malaya Das bracket Supra, we are of the view that the prayer made by the applicant deserves to be allowed. As such, the IA stands allowed. The applicant is permitted to pursue the appeal being criminal appeal number 103 of 2022 pending before this court by stepping into the shoes of the appellant. IA stands disposed of. So substitution or no substitution, she will step into the shoes of the appellant and pursue the matter. That answers your question. Correct.
And the matter is otherwise paper book is ready, man.
Yes, and in the main appeal, you write, let the appeal be listed for hearing in the month of February 2023. All right.
Item 15.
May I please,
Yes,
Lordship, this I is filed for condemnation of delay of 31 days.
31 days, it is allowed. Yes, heard Mr. D. Talukdar. Your name is Mr. P.
P.
Chaudhary. Learned counsel for the applicant, also heard Ms. L. Devi. Learned counsel appearing for the respondent stroke Nia. Full stop. This IA has been filed under section 5 of the Limitations Act 1963 with a prayer to condone the delay of 31 days in preferring the connected appeal. Full stop. Any objection?
No, Lordship.
We
I
have
don't agree.
reduced the grounds taken in the IA. Full stop. Ms. L. Devi, learned counsel for the respondent, submits that she does not have any instruction to file written objection in this case. Full stop. Having regard to the explanation furnished in the IA and considering the stand taken by the learned counsel for the respondent, we are of the view that the present is a fit case where the delay of 31 days in filing the connected appeal deserves to be condoned. Stop. Ordered accordingly. Stop. Office to register the connected appeal and list the matter for admission.
Deeply.
IA stands disposed of. Yes. I part one says so. Now, part her too long. Yes. There is a part
Lordship,
matter.
hearing. Part one hearing is also there.
There was one matter fixed for today.
Yes, part one matter is fixed for today.
Yes, where is it? Holly?
Part two hearing list fixed for today, part item 12.
It's not there.
He's not there.
Mr. Das, NJ Das.
Part one no matter to come to us.
Hearing list for hearing item 16.
16 also on the last occasion, they didn't appear. This honorable court observed. If they don't appear on the next date, amicus curiae will be appointed.
Give the- Stop. He like called up before this court. Full stop. Therefore, it appears that the learned counsel for the appellants is no longer interested to appear in this court. Full stop. Register to therefore verify from the appellant's counsel as to whether they are willing to continue to appear in this case, and if not, list the matter again in the month of February by engaging a legal aid counsel to represent the appellants. In such event, necessary papers be also furnished to the learned legal aid counsel.
Part two hearing list. Part item 12.
He is not there.
No, she-
All of other matters.
Part two hearing list, item 1, item 3, 4 and 5, 7, 8, 10, 11.
Yes, anybody ready with any matter?
Item number 15, Lordship.
Huh?
Item number 15. Here appellant is in custody since 16/6/2016, Lordship.
Let us see what is the matter.
Here FIR was lodged by the mother of the appellant, alleging that he assaulted his father, who subsequently died, Lordship. FIR, your Lordship, will find page 4.
FIR is that?
Page 4.
Yes,
May I read it?
yes.
The humble submission that I, the undersigned complainant, am a resident of the number 2 Athiabari Gaon under the Serfanguri PS at about 8:39 PM on 14/6/2016. My son Sri Bodon Suren came home from somewhere. Then my husband Michael Suren and I asked the boy why he was roaming late in the night and rebuked him. Then Sri Bodon Suren failed me on the spot by beating me with a bamboo stick and repeatedly struck my husband while he was sleeping on a cot, whereupon my husband fell down on the ground and died. This part is important, Lordship. My husband fell down on the ground and died. I therefore pray to you to punish the accused after investigating into the matter and oblige. So immediately he, Lordship, he went to the police station and he surrendered himself. That is on 16/6.
Where is the postmortem report?
That your Lordship will find.
Page 33.
Page 33.
Yes, the injury, cause of death.
Opinion, page 37, Lordship.
Hmm.
Head injury. And injuries. Page 34. Injury.
How many injuries are there?
2 injuries, Lordship.
You can't have 2 injuries by falling on the ground.
No, one Lordship, he struck on the head and thereafter he fell down and sustained injury. So for which injury he died, that is not on record.
Which are the 2 injuries?
Page 34, your Lordship will find.
Hmm.
Split lacerated injury over the right side of forehead measuring 6 into half centimeter scalp deep. Split lacerated injury over right temporal region measuring 3 into half into scalp deep.
So both these injuries could not have happened by falling down on the ground. That you agree?
One injury is caused by the
Yes,
appellant.
but either of the 2 injuries are sufficient to cause death.
That is not there. In my opinion, page 37, Lordship. In my opinion, the cause of death is instant due to shock due to head injury, which is caused by blunt object and antemortem in nature. So which is that injury that is not there, Lordship. And if your Lordship see the evidence of that informant, she also said in that manner, Lordship. I said when your Lordship will find page 9.
Yes.
PW2. My husband was killed by Bodon Suren. Bodon Suren involved in quarreling with my husband and me. The accused killed my husband. He died at once. I filed a case. I gave statement under section 164 CRPC to court. Cross. My son jobless. Bodon did not work properly. The incident occurred at night in the month of June. I was at Baranda. I asked the accused to earn. Maybe he was at the stage of intoxication. I visited the police station. I lodged the FIR at morning. The dead body was lying at my residence. The accused assaulted me also. The victim died falling on the ground.
Is it 304 part 2 case?
Lordship, there was quarrel prior to that. And he was in an inebriated state, he was consuming liquor. There was
Looks
quarrel.
like knowledge but no intention.
Lordship.
Yes.
But your
else?
Lordship, there is not only one injury, there are several injuries are there on the vital part of the body.
Yes, but then the
He has also
vital-
fallen down as per the evidence of the eyewitness.
vital injuries are in the head.
Yes.
So he has fallen down and lacerated injury by falling down is difficult.
Lordship, may I read the injury part? So and so. Split lacerated injury over the right side of forehead.
You're reading which page, which page?
Lordship, from the LCR. I don't have anything.
Oh,
I've collected, I have just noted.
PW1 is Dr.
have a look.
Lordship. I'll take.
Go through once and then make a note and then you can.
I have made a note already.
Alright.
Yes. Page 8 of the paper book.
Hmm.
Split lacerated injury over
That's
the
the
right side.
doctor, that is the
Yes,
doctor.
yes, my lord. Apart from that, lordship, the evidence of the eyewitness who happens to be the mother, my lord. First, the accused person fought with her. Then thereafter, he has assaulted. She was sitting in the veranda. It's not that clear, your lordship. The picture is not that clear. But there is a subsequent, even he went to the police station and he reported the matter to the police station. There is GD entry. 164 statement, I have not found it. I think it's not there.
164 statement is not there. He went to the police station and confessed that I have assaulted my father and he died. And thereafter he was taken into custody, but his 164 statement was not recorded.
Yes. Lordship, may I read evidence of PW2?
Yes.
Sita Hemram she's the mother.
Hmm.
My husband was killed by Bodon Soren. Bodon Soren involved in quarreling with my husband and me. The accused killed my husband. He died at once. I filed the case. I gave statement under 164 to court. Then page 10, my son is jobless. Bodon did not work properly. The incident occurred at night in the month of June. I was at veranda. I asked the accused to earn. Maybe was at the stage of intoxication. I visited the police station. I lost the FIR at morning. The dead body was lying at my residence. The accused assaulted me also, and the victim died falling on the ground. There are two events, Lordship. First, he might have assaulted him. Thereafter, he had fallen down from the bed. Lordship, then evidence of PW4. It was hearsay, your Lordship. Oh, but Lordship, CW1, judicial magistrate, his evidence is recorded.
PW3 is also hearsay.
Yes. There's no one except Lordship. CW1 recorded the
Statement of
statement.
PW2.
All right, just let me see what is there in PW4.
PW4, my lord. He wrote the Azahar. Accused surrendered before the police station as per the evidence of PW5. And weapon was recovered, seized, my lord. Accused has taken the plea of any by lord. Evidence of CW1 would be relevant. to me.
There is defense evidence.
CW court witness, man. No,
No, you
defense
said
evidence.
plea of alibi.
Clear alibi in
No.
313.
Which question, which answer?
Last question, your lordship, at page 20. I am innocent at the time. I was not present at my home.
IPC, IPC. Take the judgment. Will take it. Looks like exception 4, usually 4 part. The quarrel at us, the frustration. 304 part 2, 10 years.
7 years. Lordship. He
No,
already 6
cannot
years
be
in
10
custody.
years, my lord, because
And
Lordship-
he has given his ground for consideration for sentence, Lordship, that your lordship will find page 21. Page 21, Lordship. I am a poor person, and in absence of my father, the entire burden of the family lies on me, and hence I pray for lesser sentence.
But he's been in jail since 2016. The
Yes.
family is surviving somewhere.
and 3 more brothers are there, as per the evidence of CW1. And he killed his father, your lordship, own father. So 10 years is a lordship. It not be less than 10 years.
That is the maximum punishment. Therefore, I am praying. 7 years.
And it is on the vital part of the body, then your lordship,
The
304
cause of
part
death is
1.
not the injury caused by him, because after that he fell down and he died.
No, but why he has killed his father, he struck his mother. Why should we be lenient on him? 304 part 2 is because that is what the evidence suggests.
Right.
But what is the case? Why should someone be lenient? The court should be lenient in awarding him sentence. What is the reason?
Other ground is that
What is
he
the
was
example
never
in setting?
previously convicted, and there is no antecedent that he did some those.
Killing one's own
Because
father. This is a case where the court should be lenient.
And about from
What
the
do you say,
evidence also-
Mr. Ahmed?
Sorry.
Forget amicus curiae.
Lordship.
What do you say as an officer of the court? When a person, this provocation was not grave, somehow we may consider it as sufficient, but it's not grave. And he decides to kill his father and strike his mother. This is a conduct which deserves leniency in sentencing. What do you say on that?
The incident is unfortunate. That is, I am not denying also. But considering the age and other factors.
What was his age at the time of the
Lordship,
offense?
just, 23 years old, Lordship, at that on 18th, when it was recorded, Lordship, 2018. And at the time of incident, probably 20
16.
years.
no.
Occurrence is 2016.
16.
So he
No,
was around 21 years old.
That
That-
time?
Yes, Lordship. Therefore, I am praying. 8 years.
Your lordship may take into account that part.
He was about 21 years old
Yes,
at the time of the occurrence, is it?
Yes.
yes, now he is 23.
24, 25.
24,
And now at 24, 25, 6 years. He will be 20, around 26 he will be now.
Date of.
16 of August.
Date of judgment he is in custody.
No, from the, after the FIR, he surrendered in the, before the police, and since then he is in custody. 16/6/2016.
So during trial, he was in jail.
He was in jail. And I have checked, probably bail application were also not filed during that period.
And where do we find his age at the time of occurrence?
Page 19, you also will find 313 statement. Was recorded on December 2018 and the incident is 2016. So 2 years will be deducted, that will be around 21-20.
Lordship, let him remain for some time, my lord, because from 2016 he is there in jail. So 6 years have gone by, 4 more years, let him remain. I'll leave it to your lordship.
All right, we'll
because-
make it 9 years
Yes.
and close it. Yes, or Mr. Ahmed Leonard, amicus curiae appearing for the appellant. Yeah, let it be. For the appellant, also heard Ms. B. Bhuya, learned senior counsel and APP Assam, assisted by Mr. J. Das, learned counsel appearing for the state, who appeared for the informant, full stop. Being aggrieved by the judgment dated (18/1/2019) passed by the learned Sessions Judge Kokrajar in connection with Sessions case number 150/2016, whereby the appellant was convicted under section 302 of the Indian Penal Code for committing the murder of his father and sentenced to undergo rigorous imprisonment for life and also to pay fine of ₹3,000 with default stipulation, the instant appeal has been filed, full stop. Full stop. The prosecution case, in a nutshell, is to the effect that on (14/6/2016), the accused public appellant, Sri Badan Soren, who was out somewhere, had returned home, and pursuant to a quarrel, he had struck his father on the head with a lathi, and also causing grievous injury on his head, leading to his death. Full stop. The accused had also hit his mother with the lathi, causing injury on her body. Full stop. On 16/6/2016, the mother of the accused and the wife of the deceased, namely Srimati
Sita, PW2.
Sita Hembram, SITA, then Hembram, HEMBRM, lodged an Ejahar before the officer in charge of Sarfanguri police station, reporting the incident. Full stop. Based on the, upon receipt of the Ejahar, SFS PS case number 41/2016 was registered under section 302 of the IPC, and the police took up the matter for investigation. Full stop. On completion of investigation, charge sheet was.
Lordship, may I interrupt? I'm sorry. Lordship, this ZD entry, the accused on his own went to the police station, page 38, my lord.
Yes.
Lordship, he on his own went to the police station in fact.
Registered case number so and so. However, before that, the it appears that the appellant, immediately after striking his father, went to the police station and informed them about the occurrence. On the basis of such input, Serfanguri PS GD entry number 268 dated 15/6/2012 was made. Full stop. Thereafter, on receipt of the Ejahar dated 16/6/2016, SFS PS case number 41/2016 was registered against the accused under section 302 of the IPC, and the matter was taken up for investigation by the police. Full stop. On completion of investigation, the police submitted charge sheet against the appellant stroke accused under section 302 of the IPC. Full stop. Based on such charge sheet, the learned trial court had framed charge against the accused under section 302 IPC. Full stop. However, IPC, full stop. The charge so framed, was read over and explained to the accused. However, full stop. However, since the accused had pleaded innocence, the matter went up for trial. Full stop. During investigation, the prosecution side had examined as many as 6 witnesses, including an informant, Srimati Sita Hembrem, bracket PW2, the doctor who had conducted post-mortem examination on the dead body, Dr. Nahar Ranjan Biswas, bracket PW1, and the IO. IO is PW5, is it?
Two IOs, my lord.
And the 2 IOs who had conducted investigation and submitted charge sheet, namely the PWs 5 and 6 respectively. On completion of recording of evidence of the prosecution side, the statement of the accused was recorded under section 313 of the CRPC, wherein and whereby he had denied all the incriminating circumstances put to him. Full stop. As a matter of fact, in reply to the question number 7, the accused had not only pleaded innocence, but had also taken the plea of alibi by stating that at the time of the occurrence, he was not present at home, but had gone to Janagaon, Gaanagaon, to watch a football match and stayed in the house of his friend Sakla, Sakla Mardi, after having dinner. Full stop. The defense side, however, did not adduce any evidence. Full stop. Full stop. On conclusion of trial, the learned court below has held that the charge brought against the accused stroke appellant under section 302 of the IPC stood established beyond reasonable doubt. Accordingly, the accused was convicted and sentenced as aforesaid. Full stop. By referring to the materials on record, next para. Mr. Ahmed, learned amicus curiae, has argued that there is evidence to show that the victim had fallen down on the ground. Full stop. The medical report does not clearly identify the injuries sustained by the victim on being struck by the appellant and those that might have been caused due to falling on the floor. Full stop. As such, it is doubtful as to whether the victim died due to injuries caused by the appellant. Full stop. It is also the submission of Mr. Ahmed that there is evidence to show that the occurrence was preceded by a quarrel, and in all probability, the appellant was in an inebriated state. Full stop. Under the circumstances, this case would come within the sweep of the fourth exception to section 300 of the IPC. Full stop. On such ground, Mr. Arnold has prayed for conversion of the conviction of the appellant. In the event the court finds this is not a fit case for acquittal. Stop. The learned amicus curiae has also tried to impress upon us to reduce the to award lesser sentence upon the appellant by urging that at the time of the occurrence, the age of the appellant was around 20 years, and therefore, keeping his future in mind, the court may award a lesser sentence, a reduced sentence to the appellant. Stop. Next, responding to the above, Ms. Bhuya, learned APP Assam, has argued that the prosecution case stands firmly established from the testimony of the informant, that is the mother of the appellant and the wife of the victim, bracket, that is the PW, namely the PW2, who had seen the occurrence. Full stop. She has categorically deposed as to the manner in which the appellant had struck his father, bracket, the victim, on his head with a lathi, causing multiple injuries. Full stop. The medical evidence clearly establishes the fact that the victim had died a homicidal death due to the injuries suffered on the head. Full stop. Since the appellant had struck his father on the vital parts of the bodies more than once, causing grievous injury leading to the death of the victim. According to the learned according to the learned APP, there is no scope to hold that the appellant was not responsible for the death of his father. Full stop. Ms. Bhuya has, however, submitted in her usual fairness that it could be a case where there was no premeditation, and in such an event, this court may consider the sentence that can be awarded to the appellant by keeping in mind his tender age. Full stop. We have considered the submissions made by learned counsel for both the sides and have meticulously examined the materials available on record. Full stop. From the evidence of the PW1, that is Dr. Nihar Ranjan Beswas, it has been firmly established that the victim had died a homicidal death due to the injuries suffered on his head. Full stop. As per the medical evidence, the following injuries were found in the dead body. Double tick to double tick, page 8. Full stop. The PW1 has also proved the postmortem report exhibit 1 by identifying his signature therein. Full stop. Cross-examination of this witness was declined by the prosecution. Stop. PW2 Sita Hembram is the informant in this case. Full stop. She has clearly deposed that before the occurrence, the appellant stroke accused was involved in a quarrel with his father. Full stop. It was the appellant stroke accused who had killed her husband and he died instantly. Full stop. PW2 has confirmed that her statement was recorded by the magistrate under section 164 CRPC. Full stop. During her cross-examination, PW2 has deposed that her son was jobless and full stop. The incident occurred at night in the month of June when she was at the veranda. Stop. At that time, she had asked the accused to earn according to PW2, the accused was in a state of intoxication at that time. Full stop. The accused had also assaulted her. Stop. PW2 has confirmed that she had lost the Ejahar on the next morning of the incident. Stop. The testimonies of PW's 3 and 4. Now, a testimony of PW3 is not of much significance in this case, as he did not see the occurrence. Full stop. His evidence is more of hearsay nature. Stop. Next para. PW4, Sri Mantu Rawani, RAWN, was the scribe of the Ejahar. Full stop. He has deposed before the court that he wrote the Ejahar as per instruction of the informant, PW2. Full stop. Exhibit 2 was the affair which bears his signature. Full stop. In his cross-examination, PW4 has stated that the informant had informed him that on the day of occurrence, the deceased had scolded the accused and there was a quarrel between them. She had also told him that the deceased was in a drunken condition at the time of the occurrence. However, he did not see the occurrence. Next paragraph. PW5, Sri Binanda Basumatari was the officer in charge of Serpanguri PS on 15/6/2016 when the 15/6/2016, full stop. PW5 has deposed that on that day at around 8:30, it should be PM, 8:30 PM.
Yes.
8:30 PM.
15/6 at around 8:30 PM. Many people don't know the difference between AM and PM. Not the IOs, the PPs, many don't know. They write in the morning PM, in the evening AM. About 8:30 PM, a person disclosing his identity as Bodan Soren, bracket, accused, bracket closed, surrendered before the police station. by confessing that he had committed the murder of his wife. Full stop. He made a GD entry and thereafter visited the place of occurrence and saw the dead body of the victim lying on the ground with head injuries. Full stop. PW5 has stated that the wife of the deceased was also present at the place of occurrence. Full stop. He had recorded the statement of the witnesses, including the informant, bracket PW2, who had handed over the lathi used in the occurrence. Full stop. He had seized the lathi. Full stop. The IO bracket PW5 has stated that as per the witnesses, it was the accused who had committed the murder of his father with the help of a lathi. Full stop. PW5 has exhibited GD entry number 268 dated 15/6/2016, as well as the exhibited GD entry so and so as exhibit 3, as well as the Caesar list as exhibit 4. Full stop. He has also confirmed that inquest was done on the dead body and the same was also sent for post-mortem examination. Full stop. According to PW5, he had recorded the statement of the accused under section 161 CRPC, wherein he had confessed his guilt, but the statement of the accused was not recorded under section 164 CRPC. Stop. Sri Ram Charan Rabha was the officer in charge of Sarfangari police station who had received the case diary from the PW5, collected the postmortem report and thereafter submitted charge sheet bracket exhibit 5 against the appellant. Stop. Cross-examination of this witness was declined. Full stop. Sri A. Saikya was the judicial magistrate first class on duty at Kokrajhar on 16/6/2016, when the statement of PW2 was recorded under section 164 CRPC. CW1, he was examined as CW1. Full stop. This witness has deposed the manner in which the statement of PW2 was recorded in the recorded under section 164 CRPC, and had also proved the statement as exhibit X by identifying his signature therein. According to CW1, the witness had put her thumb impression on exhibit X in his presence. Full stop. During his cross-examination, CW1 has stated that when he tried to inquire,
164 is not in the paper book, but it was exhibited, Your Lordship, it's on record.
He tried to inquire as to why the accused had killed his father, but the witness had replied that she did not know the reason and that the accused was in a state of intoxication while committing the murder of his father. Stop. Full stop. Next. From an analysis of the evidence available on record, it is firmly established from the testimony of PW1 as well as the postmortem report exhibit 1 that the victim in this case had suffered a homicidal death due to the injuries sustained by him on the head. Full stop. Therefore, the homicidal death of the victim is well established. Full stop. The PW2, that is the mother of the accused and the wife of the deceased, is an eyewitness to the occurrence. Full stop. She has categorically deposed that it was none other than the accused stroke appellant who had struck the victim on the head with a lathi. Full stop. The testimony of PW2 is not only free from any inherent contradiction, but the same also finds due corroboration from her statement recorded under section 164 CRPC, marked as Exhibit X. Full stop. Full stop. Full stop. Next para. We also find from the testimony of PW5 that soon after the occurrence, the accused had himself surrendered before the police station and confessed that he had committed the murder of his wife. However, no statement of the accused was recorded under section 164 CRPC, full stop. In view of the provisions of section 25 and 26 of the Evidence Act, the statement, the confession made by the alleged confession made by the accused before the police cannot be proved against him, and therefore the conviction of the accused appellant has rightly not been based on his confessional statement. However, in view of the evidence adduced by PW2, we are left with no manner of doubt that it was none other than the appellant who had grievously injured his father by hitting him with a lathi on his head, leading to his death. Full stop. Having held as above, the only issue that would now survive for consideration by this court is as to whether this case would come within the fold of any of the exceptions of section 300 of the IPC. Full stop. Exception 4 of section 300 reads as follows. You have to quote it. Full stop. From a careful analysis of the testimony of PW2, we find that the accused stroke appellant was unemployed, and just before and he used to have frequent quarrels with his father on such count. Full stop. Just before the occurrence, the accused was reminded of his status of his unemployed status. It also appears that he was in an inebriated state. Full stop. When a young person of the age of the accused is unemployed and he is reminded of the same time and again, it is possible that the same would enrage the accused more so if he is in a state of intoxication. Full stop. This is exactly what appears to have happened in this case. Full stop. On the persistent queries made by his parents, pointing out his state of unemployment, the accused stroke appellant appears to have lost his temper, and in a fit of rage, fit of rage and heat of passion, he picked up the lathi, within quotes lathi, bracket stick, which was used to block the doors of the house and hit his father on the head, which had led to his death. Full stop. The accused stroke appellant was so enraged that he did not even spare his mother, who was also injured due to the blows dealt to her by the accused. Full stop. What is, however, significant to note herein that immediately after the occurrence, the accused had gone to the police station and surrendered before the police by admitting and surrendered before the police. Full stop. Full stop. From the above chain of events, we are of the opinion that there was lack of premeditation on the part of the accused appellant, and he had acted in a heat of passion, having lost his temper on being reminded by his parents about his state of unemployment, which undoubtedly is a sentimental issue, which could undoubtedly be a very sentimental issue for an unemployed youth of his age. First up, as situated thus, we are of the view that although the appellant had the knowledge that by hitting his father on the head with a lathi, he could cause death to him, yet it appears that there was no intention to kill his father. First up. As such, we hold that this case comes under the sweep of section 304 part 2 of the IPC. Consequently, we set aside the conviction of the appellant under section 302 IPC and convict him under section 304 part 2 of the IPC. Full stop. We set aside the conviction and sentence awarded by the learned trial court to the appellant under section 302 of IPC and convict him for committing an offense under section 304 part 2 of the IPC. Full stop. Insofar as the jail sentence of the appellant is concerned, we have taken note of the fact that he was barely 20 years old at the time of the occurrence and therefore has a future to be lived. Full stop. Although the irresponsible act of the appellant had led to the death of his father, yet keeping in mind the overall facts and circumstances of the case, as well as the future of the appellant, we award him jail sentence of 9 years, rigorous imprisonment. Full stop. The period of sentence so awarded by this order shall stand adjusted against the period already undergone by the appellant at the trial stage as well as after his conviction. Full stop. Insofar as the fine imposed by the learned trial court is concerned, the same will remain unaltered. The appeal stands allowed in part, sent back the LCR. Before parting with the records, we wish to put on record our appreciation for the valuable services rendered by Mr. A. Ahmed, learned amicus curiae, in deciding this appeal and recommend that the registry may pay just remuneration to him as per the existing norms.
Here also there is set of period that during investigation and after judgment also. During investigation.
Set off would be set off against the period undergone during investigation and after his conviction.
During trial also he was.
During investigation,
During trial and
comma,
after.
trial, as well as after his conviction. Now it's okay,
If any,
if any. So what else? What else? Mr. Atal, what are you waiting for?
My item is 68, but my lord, 67 is attached with 68, and in 67 private counsels are there. My lord. I haven't seen those private counsel. Otherwise, I'm ready with 68, my lord. Altogether, 3 accused persons. were there,
Monday
my
could be a more auspicious day for you then.
lord. My lord,
You inform them, we'll take up. Let us work on some judgments also. We have already heard some matters. Monday we'll again start.
This matter will remain, earlier one will remain as part heard. Yesterday's matter.
It will depend on what is the bench
Oh,
composition.
yes.
That we don't know.
Yes.
If the same bench continues, then it will be part.
Lordship, lordship.
Otherwise, we'll see what happens. We don't know what is the list to lesson. The list is coming. So at the
One
moment,
part heard matter with Honorable Justice Thakuri is fixed. for
yes,
6.
there are parted matters with other honorable judge. So therefore, that's why for now, let's finish up the judgments in the matters we have heard already.
My lord.
Today only 2 judgments. Yesterday also, that judgment is ready. And another 2-3 judgments are there. We'll work on this, and Monday again we'll start fresh hearing. All right. Yes.
Lordship, if Ajaz matter is